Welcome to today's program titled Adapting to Change, Legal Impacts on Healthcare, Antitrust, and ESG in 2025. All participants are in listen-only mode. However, you are encouraged to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our moderator, Sean Wood. Sean, you may begin.
Thank you, Sadie. Hello, everyone. I'm Sean Wood, and I chair the Commercial Litigation Practice Group here at Seyfarth Shaw. Welcome to the first installment of our annual webinar series, which is built around the publication of our annual commercial litigation forecast. For each of the last 5 years, we have published this forecast to discuss and predict litigation trends in a wide array of practice areas, ranging from franchise and distribution law to intellectual property to trade secrets to privacy and cybersecurity. Today, we're going to zero in on 3 key areas, starting with trends in healthcare litigation, and then moving on to antitrust enforcement, and then finishing off with the co-chair of our Impact and Sustainability Group, Amina Majid. Please feel free to send us your questions in the chat bar, and I'll do my best to work those in as we discuss these items with our esteemed speakers over the course of the next hour. To kick things off, we're starting with a deep dive into healthcare litigation, an area that continues to evolve with new regulations, enforcement actions, and industry challenges. And here to guide us and navigate through those trends is Jesse Coleman. Jesse is a veteran trial lawyer from our Houston office who serves as the national co-chair of our healthcare group. Jesse, welcome and thank you for joining us.
Thank you, Sean. Glad to be here.
I'd like to start by asking you about false claims litigation. And I know we've seen higher levels of enforcement more recently. And I was hoping you could explain to us what you're seeing over the past couple of years, as well as whether you expect it to continue under the new administration.
Thank you, Sean. We do expect the enforcement of the FCA to continue robustly under the new administration. It's a tool that's been used administration over administration on the right and the left, Republicans and Democrats equally, and we see it continue in the area of healthcare. Healthcare is almost always the largest industry in which there are recoveries under the FCA. In this past year, there's $2.9 billion in settlement and judgment overall. Of that, $1.67 billion were related to matters involving the healthcare industry. So this would be managed care providers, hospitals, pharmacies, laboratories, long-term acute care facilities, and physicians. We also see record enforcement efforts, 558 settlements and judgments. This is the second highest number in the FCA's history. And with such a large piece of the federal government's budget going to programs, healthcare programs, it's unsurprising that this is an area in which we're going to see a lot of False Claims Act enforcement.
And in terms of private individuals suing on behalf of the FCA or on behalf of the government under the FCA, I know that's a topic we're going to be doing a little bit deeper dive into in one of our future webinar series, but I wonder if you could briefly touch on whether the current framework is under fire.
Yeah, so 2 quick points on that, Sean. There's a procedure under the FCA that folks in the area are very familiar with. It's a QI-TAM or QI-TAM whistleblower provision that allows individuals to act essentially as private attorneys general. They get to act on behalf of the government. They can bring claims, seek investigations. They tend to be whistleblowers, individuals within an organization that claim to see fraud against the government. And what will often happen as a result of that is the government will then be notified as part of that process. They'll take over the investigation. The individual qui tam relator or the qui tam whistleblower will have the opportunity to then get a large portion of the settlement if one comes out. Sometimes the government will leave the qui tam plaintiff, if you will, to seek recovery on their own. And what we see, the type of claims that we see for that traditionally and most recently are opioid epidemic claims, anti-kickback claims, and generally claims related to unnecessary services and substandard care. We saw a lot of that in the COVID period, especially with it being under fire in particular. And as you mentioned, we're gonna talk a lot about this more in a future episode. But there has been at least one case, and there's been a movement to seek that this statute gets struck down. We had a recent case out of Florida where a judge determined that the qui tam provision of the FCA was unconstitutional because it violated the Constitution's appointment clause. Specifically, Judge Catherine Kimball Mazzell held that the FCA relator provision, the qui tam whistleblower, was not an officer of the United States. They're identified as one as part of this process, but they've not been properly appointed according to Article 2 requirements. So both the relator and the government have appealed this. There's oral argument likely at the 11th Circuit shortly. But I think we can continue to expect challenges such as this. But in the meantime, I think that we're gonna see strong enforcement under the FCA, both in terms of whistleblower actions and government investigations.
And in the transition to the new Trump administration, is there a particular focus under his executive orders that you expect to see in terms of any stepped up enforcement?
Well, I think we'll continue to see a lot of healthcare related FCA actions. I don't think that's going away. I do think one area of note that stretches across healthcare, but also impacts almost all other industries is the Executive Order 141731. This is the DEI Initiative Executive Order. The order directs the head of each agency, as many have heard, to require federal contractors and grant recipients to agree that they're compliant in all respects with federal anti-discrimination laws, and that they are not operating any programs promoting DEI, diversity, equity, and inclusion, that violate applicable anti-discrimination laws. So this would also impact healthcare organizations. There has to be a new certification. There's materiality requirements associated with federal contracts. And so what this really does is this brings the power of the FCA to bear in DEI matters. Now, since we went to print with our commercial litigation report, and I think you're going to be hearing this again and again, these are all areas that are developing. We've seen the DEI executive order been challenged, and originally February 2025, a Maryland judge granted a nationwide preliminary injunction against that, and then identified that it applies to all federal executive branch agencies, departments, and commissions. So they across the board. However, just on a few days ago, the Fourth Circuit reversed this injunction, and so federal agencies can resume presenting federal contractors and grantees, including in the healthcare industry, with certifications required under the executive order. So this is a big deal, and this impacts folks. I mean, we're watching like a tennis game how these things are going back and forth between the administration and the federal courts, and I think we can continue to expect to see that throughout at least the early days of the administration, or at least until Congress steps in and starts deciding where some of these things land statutorily.
Yeah, to say developing is a euphemism. I think the tennis match, as far as the back and forth, is perhaps more apropos. And to clarify, the argument would be then in those actions is that the DEI initiative itself is what could be considered discriminatory, correct?
That's correct, and the executive order is in the material areas is careful to say promote any DEI that violates federal anti-discrimination laws, and so there's some argument area in there, I think, that people are going to take up and say, well, my DEI program doesn't violate federal anti-discrimination laws. The terms themselves, other people would argue that those terms inherently reflect and discuss things that would violate the anti-discrimination laws. I think there's a whole spectrum of arguments, I think, that are going to be engaged and that have been engaged in this area. There's the challenges to it. The executive order include void for vagueness, for instance, and so that would be on the spectrum of saying, well, what do you mean by DEI, and what do you mean by how is that necessarily violating the anti-discrimination laws?
Gotcha. So along the same lines and contrasting the approaches followed by the prior and the current administrations, what is happening in the area of drug pricing, or I think what you called in your article, the war on drug pricing, and tell us a little bit about that.
Sure. So always looking to catch a good headline on this. So drug pricing obviously is a very critical area of the industry, and it is an area that is constantly in dispute. This current quote unquote war on drug pricing centers around the Inflation Reduction Act, which was passed in 2022. It provides Medicare the ability to directly negotiate with pharma companies prices, particularly prices for drugs that are of a high expenditure, single sourcing, that don't have generic or biosimilar competition, critical drugs to people's livelihood, but at the same time are probably backed by billions of dollars of research that need to be recouped. So that's a quick way of describing what some of the arguments are. These negotiations are going on in different cycles. There were initial drugs that were put out last year that discussed in the first round, and then more recently, in fact, since we've gone to print, CMS announced agreements had been signed with manufacturers as to 15 drugs on a second cycle under Medicare Part D, and that's what this is really about. So the war side of this, if you will, is there are at least 9 lawsuits pending against this drug pricing negotiation program on the basis of constitutionality and statutory grounds. Drug manufacturers argue, for instance, that they're being forced to give selective drugs to the government without fair compensation. So it's an illegal takings argument. They're being compelled to call this program a negotiation when in fact it's being dictated to them, they would argue. And say that the final prices are fair. They would say this is a violation of the corporation's freedom of speech. And so you've also got arguments that under the 8th Amendment, that the penalties being levied on drug manufacturers for not complying are so high they constitute excessive fines. And so you really do, you have a really engaged dispute here. There's due process clause issues. And of course, you bring this under the Administrative Procedures Act, for instance, challenging this. So from what I've seen, and again, we've tried to be as absolutely up to date as possible as we go through this, but things are changing all the time. No court has yet sided definitively with the pharmaceutical industry on these arguments, but these are continuing to go on. And a court, for example, under the Administrative Procedures Act, could set aside statutes depending on or regulations associated with those statutes to the extent that it's being based on a promulgation of a rule by the Secretary for CMS. Those regulations could be set aside under the Administrative Procedures Act. So definitely an area that we want to keep our eyes on. I can tell you that as of February, the DOJ has filed an appeals court brief supporting the right of Medicare officials to negotiate drug prices. So this suggests, at least preliminarily, that the Trump administration is willing to maintain this drug pricing negotiation program. Although what happens next month, next week, tomorrow could really be anyone's guess.
And was part of it? It was an executive order that was implementing part of the Inflation Reduction Act that was passed by President Biden, correct?
So there was a executive order that had gone out by President Biden requiring the Secretary of Health and Human Services to select and assess certain healthcare payments and delivery models associated with the IRA that may in its process lower drug costs, promote access to drug therapies. That was actually rescinded. So a different tennis match or a different back and forth here. Now we have between the executive orders. President Trump rescinded that executive order along with some related executive orders. This isn't likely to impact the IRA manufacturing and negotiation process because a lot of that's statutory. But it does indicate that Trump's paying attention, or the part of his administration is focused on these issues. It's still unclear to see exactly how that's going to ultimately impact the ultimate process. The negotiation process, the prices aren't expected to come out or expected to be implemented until 26 and 2027.
Okay. And turning then to a topic that I know is near and dear to your heart, as your trial experience extends deep into the trade secret non-compete space. I was hoping you could address both federal and state bans on non-compete clauses in employment agreements, in particular, and the focus on the healthcare industry, as I know certain states have made that a priority.
Absolutely. So starting with the federal landscape, anyone following this area is probably very aware that the FTC tried to pass a nationwide ban this past year. They promulgated a rule that prohibited nearly all, and eventually sunsetting out to all non-competes between workers and employers. There's a small exception for highly paid executives. This was immediately challenged in the courts. This would, by the way, just to be very clear about the healthcare industry, this would have impacted for-profit healthcare organizations, but not non-for-profit or not-for-profit or nonprofit, which would have had, in my opinion, a very strong distortion in the market, because you've got anywhere from 3/5, 2/3 to 3/5 of the industry that are either nonprofit or government related, and so may not fall under the FTC. So you have this small rump minority here that's going to be impacted by this ban. Would have had a real strong impact on it. It was set aside under the Administrative Procedures Act because it was a rule. The Fifth Circuit, it's currently appealed to the Fifth Circuit, and the DOJ has recently asked for him and granted a stay while the administration works out whether it wants to move ahead. The current chair, who wrote a blistering dissent to the rule last year when it was promulgated, saying that the FTC doesn't want it anymore. And so it'll be interesting to see even if that were to happen. I don't think it will. I think that's done with. So where does that leave non-competes? Well, it's where it's traditionally laid for hundreds of years now, and that is with the states. And again, to focus on the healthcare side of this, most states allow for non-competes in some form or another. They tend to follow a very similar format as to what the reasonableness requirements are with regards to geography, scope, time frame, and so forth. But what we see are a lot of arguments that healthcare needs to be treated differently, that there are specific ideas or there's specific interests that need to be protected in the healthcare space. And so we see a lot of lobbying at the state legislature level, and we see a lot of carve outs and exemptions and bans for certain types of non-competes with physicians. And so this could keep an attorney busy just 50, on the 50 states 24/7. We do have folks, just so you know, that are following these things very carefully. But I can tell you that, for example, Illinois, Louisiana, and Pennsylvania have recently passed legislation limiting non-competes in the healthcare sector. Sometimes this involves physicians. Sometimes we're talking about allied healthcare professionals. Illinois' legislation limits non-competes for mental health professionals and first responders to veterans if it's likely to result in an increase in cost. Louisiana has to do with the temporal scope of non-competes for primary care physicians. And then Pennsylvania limits the scope for non-competes for healthcare practitioners to no more than 1 year, and only if the healthcare practitioner terminated the employment relationship. So if they were fired, that would be different. We see a whole slew of new ones coming out this year as well that are on the horizon. Arkansas, since we've gone to print, has passed a healthcare exemption or restriction on the non-competes, where it clarifies that non-competes that restrict the right of physicians to practice within their scope of practice are void. So we see a lot of these legislatures looking to uphold non-competes generally because they do represent a legitimate business interest of businesses. And I would argue even in the healthcare space, they continue to represent legitimate business. You still have confidential information. You still have training, specialized training. You still have goodwill. You have customer relationships. All of these things exist very much in the healthcare space, as they do in any other industry that's forward facing towards personal services. But I think what you're seeing with regards to this is a recognition, perhaps in some spaces, that the physician patient relationship is also an interest that needs to be carefully protected, and the provision of healthcare services. And so you'll see exceptions that allow for that to continue, for instance, or to otherwise restrict how these non-competes can impact that relationship.
That's what motivates these state legislatures that have had such a specific focus in the healthcare industry, right? The concept of choosing one's own physician, the physician moves and you want to go with the doctor. But in effect, is that really impacted necessarily if the customer chooses, if the patient chooses to go to the physician at the new location anyway?
So no, I really don't think it does. I think it's often used as a reason to create these exceptions. But as in all legislation, it can be overly or under um, expansive. And so in most of these cases already you have exceptions that say if a patient wants to follow the physician, they certainly can. A lot of these specifically carve out the ability to take your patient lists with you, and to ensure that the patient knows exactly where you're going. As the great economist Thomas Sowell said, there are no solutions, only trade-offs. And so really what you're looking at here is a bunch of trade-offs that are trying to find a narrow area. Now, of course, physicians are going to use this process, and other healthcare professionals to push even harder. And they've been successful in some areas to say there are no more non-competes for healthcare professionals in some ways. So they've convinced the legislatures. But in other areas, they're a bit more circumscribed. There are buyout provisions, for instance, as well. And so I think we're going to continue to see, particularly with the failed effort of the FTC to do a nationwide ban, we're going to continue to see individual states that are looking to frame their non-compete laws in such a way that protect the legitimate business interests on both sides.
Got it. Well, listen, I know we're almost up for time, but if you could just touch briefly on vaccine litigation, which I know that COVID for many of us seems to be in the rearview mirror, and in courtrooms challenging vaccine mandates that may or may not be true, and who knows where we're heading into with the measles. But can you just touch on that briefly?
Sure, absolutely. So we do feel like COVID is in the rear view. I agree, and I think everybody wants it to be there. But the wheels of justice, particularly private law, in torts and so forth, and including statutory causes of action, move very, very slowly. And so we're still seeing the courts full of vaccine policy litigation, where a company will have terminated or restricted an employee's position because of their refusal, for example, on religious grounds to be vaccinated. And these cases still do high back to the pandemic period. And you see constitutional claims in here. You see Title VII claims. You see ADA claims. You see various state law Civil Rights Act claims that are going on. And one could think, well, this is going to work itself out, and we'll be done with these soon. But it's hard to say if that's indeed the case. We may have another pandemic. We may have other types of problems. I think measles has reared its ugly head in some areas again. And so there's going to be a clash of interests again with regards to a person's personal rights to determine religiously what they believe that they should be required to do in the workplace, and those legitimate interests of an employer with regards to their ability to conduct business. So I think we're going to keep seeing that. I think I have to say that one of the biggest surprises in all of this is Robert F. Kennedy Jr. being head of HHS. And the impact that has, I think, is still very much unknown. Somebody who has been against vaccines in many respects and in many areas. And so how that's going to impact things. Somebody who has spent his life on a different political spectrum, at least from where our current president sits today, now being head of the largest health organization in the world. It'll be very interesting to see how that might impact all sorts of legislation, litigation, and rule promulgation moving forward.
Well, we'll all stay tuned, right, as things change, may or may not change dramatically. So thanks so much, Jesse, for that insight into the complexities of healthcare litigation. Moving to our next team member, as legal and regulatory scrutiny continues to shape the industry, one critical area drawing increased attention is antitrust. To explore how competition laws are impacting businesses and enforcement trends, I wanted to welcome the co-author of our antitrust forecast, Sam Rowley. Sam is based in our Boston office and serves as a key member of our nationally recognized antitrust and competition group. Welcome, Sam.
Thanks, Sean.
Sam, with the picking up where I left off with Jesse, with the shift from a Democratic to a Republican administration, one might expect substantial changes in 2025 in terms of antitrust enforcement. But can you tell us if that's a reasonable expectation this time around?
Right. The short answer is no, it's not a reasonable expectation to expect or anticipate substantial change. Now, traditionally, it's much easier to predict what a new administration might bring in terms of antitrust enforcement. The general rule of thumb has been sort of over the last 50 or 60 years that Republican administrations are a friendlier antitrust climate for business. More deals get done, more deals sort of sail through the approval process. Less litigation by Republican administrations under the Sherman Act, which prohibits unlawful sort of restraints of trade or other anti-competitive behavior. But we're in different times with the Trump administration. But let me just give you a little bit to understand sort of what we might expect for change or not, or consistency. Let me just give you a little bit of context. I think it's important to understand what antitrust enforcement looked like in the Biden administration. In short, both the Federal Trade Commission and the Department of Justice, which are the two agencies tasked with enforcing the antitrust laws, took very aggressive positions under the antitrust laws, positions that frankly had never really been seen or hadn't been seen in decades at the federal level. So for example, at the FTC, Biden installed Lina Khan, who served in a very sort of high-profile role for a number of reasons. One of which is the non-compete ban was sort of her brainchild. But she was known to take very sort of aggressive positions, both in merger enforcement and in litigation itself, where she really kind of took the view that mergers themselves are sort of presumptively anti-competitive. And that's not a position that any antitrust enforcer had taken in the US since the 1960s, really. And so under her leadership, the Federal Trade Commission brought substantial policy changes to guidelines that pursuant to which the FTC and DOJ tend to operate. Both amending guidelines and then withdrawing some of their previous policy guidance. And the DOJ fell in line too. The DOJ antitrust division under Biden was headed by a guy named Jonathan Cantor, who was largely aligned, although just not as sort of high profile in the public as Lina Khan. And so you saw a lot of litigation brought to block mergers and a lot of other litigation against particularly big tech companies. Now, Lina Khan and Jonathan Cantor, they've lost in court several times, especially on the merger enforcement front. But some would say that their aggressive sort of enforcement approach had like an interim effect on deal activity in the market. So they kind of suppressed the deal volume. So we may see a return or a little more deal activity, obviously depending on what happens in the stock market. But we may see a little bit more activity return because there is just a general expectation that in a Republican administration, the climate will be friendlier. Now, I will say it is likely to be the case that generally overall for most industries, the antitrust enforcers under the Trump administration will be friendlier to business. I would say that's particularly going to be true in a couple areas. One would be the private equity space, where Lina Khan especially focused very heavily on private equity. There was a concern under the Biden administration that private equity firms would do these serial acquisitions where they would acquire a company in a particular industry, maybe a couple of years later acquire another one, and over time they would aggregate power that way. So there was a focus on private equity. I think Trump's antitrust enforcers will be less focused on private equity. Healthcare too, actually, I think the Trump administration will be less focused on healthcare than the FTC and DOJ under Biden were. So there will be some changes. I think also one other area where I think we can expect the Trump administration to be a little friendlier to business is that when businesses come to the FTC and DOJ looking for merger approval, either merger approval of mergers or of acquisitions, that in most industries, I think the administration will be less likely to pull the trigger on litigation and more open to finding amicable ways to restructure the deal to resolve any antitrust concerns to the extent there are. So overall, I would say it's fair to say it's probably going to be a friendlier climate for business, but there's going to be a lot of continuity too.
And on the latter point, there's like an asterisk next to it, right? Because in terms of what we're predicting on, this is a shift to a Democratic to a Republican administration, but a more populist Republican administration. And I'm dabbling enough to be dangerous in reading about the so-called conservatives, which, as I understand, a rather unlikely fan club that Lina Khan managed to garner on the right. Can you talk a little bit about that and what uncertainty that might bring to the coming couple years?
Yeah, absolutely. You're exactly right. And that's where the continuity comes in, is that Lina Khan took a populist approach that, frankly, is quite attractive to, many in the Republican circles today with its kind of shift to a more populist approach. And so the new chair of the Federal Trade Commission is a guy named Andrew Ferguson, who served with Lina Khan as an FTC commissioner, as a Republican. Trump chose Ferguson to replace Khan, but he's been quite outspoken in many areas that show, he is somewhat aligned with many of the positions that she took. On the DOJ side, Gail Slater was just confirmed last week. She's Trump's pick to head the antitrust division at the DOJ. She has long been an outspoken critic of big tech, and so I would say that the one industry in which you will see a lot of continuity with the Biden administration is that there will still be very aggressive antitrust enforcement against big tech. And that really, frankly, started under the first Trump administration. A lot of the lawsuits that you saw brought under the Biden administration against all of the sort of, everyday name big tech companies that we're all aware of, most of those began as investigations under the first Trump administration. And Trump himself is in fact, when he nominated Gail Slater to be the DOJ head in February, he, I think, said something like, big tech, he chose her in part because big tech has, in his words, run wild for decades. And so I think that's a clear signal that the enforcement approach that Lina Khan took against big tech will continue. And in fact, the Trump administration has already brought litigation to block a very sizable acquisition by Hewlett Packard in the tech industry. So that's its first sort of foray into the courts in the big tech industry. And also, just last week, there's a trial coming up later this year against one of the largest tech players in the world. The FTC actually had to run into court and ask for an extension of the trial date because of some of the staffing uncertainty. And we can put a pin in that, but that's one area that's kind of uncertain at the moment, is what will some of the staffing changes mean for these agencies and their ability to enforce the antitrust laws. But But Andrew Ferguson, members of his team had to ask the court to delay the trial because there had been some staffing changes, and I think my understanding is that several of the FTC antitrust lawyers took some of the buyout being offered by President Trump. But he backtracked on that a couple days and ran back into court and said, no, actually the trial date is still on. And in his statement that he released, he said, I will never back down from taking on big tech. So if that's not a clear indication of where Trump's antitrust regulators stand, I don't know what is. But yeah, we're going to see a continuation of a very aggressive scrutiny of the big tech industry under the new administration.
And beyond big tech, or I guess what sounds like a technology issue, I know it's something you and your co-authors touched on in this year's forecast, but it discussed crackdowns on algorithmic pricing. And can you just talk a little bit about what you're seeing in that area?
Yeah, I mean, that's another sort of area of enforcement that started to rise under the Biden administration. There's been so many changes in technology, obviously, particularly over the last, that have really started to accelerate over the last 5 to 10 years. And Lina Khan started to focus on the notion that across many industries for decades, long before software programs were available, very common in industries for companies to go out and purchase or contract with third-party vendors who collect data, pricing data, worker compensation data, output data, various financial performance metrics in the industry among various competitors, aggregate that data up, anonymize it, and then sell it back to the competitors. And that's called information sharing. And that's long been a topic of antitrust law. And for the most part, a lot of practices, information sharing practices, have been deemed to be lawful. And in fact, the DOJ had a set of policy guidelines that very clearly established safe harbors by which companies, particularly in the healthcare industry, would be free from prosecution, as long as they follow these particular guidelines about what they could and couldn't do with information exchanges. But with the advent of AI and algorithmic software, it's turned out that there are a lot of third parties who now are able to aggregate data and use algorithmic and programming tools to really sort of turbocharge what competitors in a particular industry can do with that data. And so now you see it's quite common in various industries for competitors to purchase algorithmic pricing data from a third-party vendor and then maybe make their pricing decisions much more frequently, more like in real time, based on what the data shows, often making pricing decisions based on what the software program recommends. And so Lina Khan came to the view that there may be some sort of per se unlawful issues there where competitors were able to collude and fix prices through algorithmic pricing programs. And so that she brought there was a number of lawsuits brought by private parties, private litigants, that the DOJ or FTC sort of issued statements of interest joining the plaintiffs. And then DOJ itself has brought a couple of lawsuits, on theory that algorithmic pricing has been facilitating unlawful price fixing in certain industries. So a question going forward will the Trump administration take the same kind of view that Lina Khan and the DOJ took under the Biden administration? And so far, I think the indications are yes, that there will be still a close scrutiny. There is a concern in the Trump administration that the technology available is really allowing competitors to price fix or collude in a way that they couldn't previously. So I think that is another area that we'll see where we'll see less change than we might otherwise would in the administration shift.
Yeah, so meet the new boss, same as the old boss, to quote Pete Townsend, right? Who knew that there'd be this much continuity, I guess. But we appreciate the insightful discussion of antitrust, Sam. Thank you so much. And
absolutely.
Moving to our final team member for today's webinar, As we consider the evolving regulatory landscape, another key area of focus for businesses today is impact and sustainability. And to explore how companies are navigating these challenges, I'd like to welcome Amina Majid, Seyfarth's Impact and Sustainability Partner based in our Chicago office. Welcome, Amina.
Thank you, Sean.
Amina, ESG has become a charged acronym in the current climate. What do we think about that terminology, and what does it mean for those that are focused on impact and sustainability?
Yeah, it certainly has been charged, and I think, you know, ESG stands for environmental, social, and governance. You know, if it had an identity, it's certainly suffering an identity crisis right now, and it's taken a beating since coming to the mainstream. So, you know, right now companies are really caught in between this growing, globally fragmented regulatory environment that's advancing disclosures and diligence schemes. And it's moved from voluntary to mandatory. So when it first came out in 2020, companies were really putting statements out around DEI and climate more from a push societal pressures, you know, consumers and investors. And now we're really in a mandatory environment around those disclosures. And that's in between. So there's that on one side. And then on the other side, we have this pretty vocal anti-ESG movement in the U.S. And we're also seeing that with changes in the administration at both federal level and across many states while this kind of pro-ESG movement continues. So I think to think about that, you know, and how that frames litigation risk, I think it's important to go back to a couple fundamentals. You know, ESG is marked by transparency and accountability. It cuts both ways, as we see with litigation, you know, and it also gets talked about as a very monolithic subject when ESG is really a framework covering a host of topics. You know, today we'll mostly focus on the climate-related stuff, but, you know, obviously there's issues around DEI, and again, mostly stakeholder pressure. But two things happened back in 2020. We had the social events where companies were sort of pressured into making statements. And then on the other hand, we had the institutional investing community emphasizing this need for companies to take into account what they call ESG factors, because there was this view that you need to assess business risk and long-term shareholder value, and that continues to be debated. But what that did was it allowed this conflating of agendas, political, social, with financial risk. And I think we've been muddying through that since. So right now, you know, where we are is on the green front, climate, environment, you know, companies actually have been advancing and investing and disclosing on their sustainability efforts. And we're in a business environment where, you know, a lot of surveys are coming out with the Trump administration and its anti-ESG view, where business is still going to continue with their sustainable investments along with more and more robust disclosures. So we know it's not going to go away. So I would sort of end with that background is, while the external forces driving the dialogue have definitely shifted, ESG, I would argue, is really and always should be looked at as integral to business strategy. So you're not doing it for the sake of it. You're not doing it because of a political agenda. You're really doing it because there are topics that are connected to a company at sort of driving and executing on their mission critical matters and back to their purpose. And that really takes you to governance and oversight. And I think that framing, so sort of a lot of the cases and greenwashing are focused on advertising or marketing. When you bring climate into the broader dialogue, you know, it helps to look at it from more of a governance and oversight issue. And now business is also recognizing the risk to the business. There's been a big increase in 10Ks mentioning greenwashing claims in particular as being a material risk that they have to navigate. So I think companies are recognizing the benefit of it. They're recognizing it as a risk, and they're really ready to undertake managing greenwashing risks.
And you know, just when I think I've got my arms around what the word greenwashing means, and in terms of the spectrum of what it can mean,
Yeah.
I hear terms like green hushing, and then it all falls apart on what I think I understand. So can you kind of walk us through the terminology a little bit for those of us that aren't doing this day to day in your space?
Sure. So I think greenwashing happens at a couple levels. You know, it's generally speaking, it's overstating or possibly misleading how sustainable a company really is, whether it's at the company level or it's in a particular business practice or at, you know, the consumer level within a product. So I think there are
and it's whether intentional or unintentional, right? Even if is that yeah.
Right, exactly. You know, you're kind of going about and you're thinking, yep, we're responsible, we're sustainable, you know, and you put statements out to that effect, you know. So I think there's also an element in the investment space. You know, there's a lot of labeling of funds that are ESG or clean energy, and, you know, whether that name and that label truly represents the holding, you know, as to the objectives of that fund. So it is a little bit of a fluid concept, and I think it can go from, you know, intentional deceit all the way over to sort of a wishfulness. The green hushing, that's pretty new, fairly new, you know, and sort of natural. You know, we're sort of seeing it obviously in the DEI space. You know, you might call that blue hushing. Over here we got green hushing. So that's really stemming from the anti-ESG movement. You know, many companies have put out what's called net zero goals or climate neutral goals or desire and aspirational things that really didn't have a pathway to get there. And then you've got, again, those two tensions, you know, in the marketplace. So companies are like, okay, well, let me take a pause, step back, and not really say much, and let me figure out, you know, what's happening within the corners of our organization. So they get quiet about it, which opens up a different risk. But it's definitely a reaction to our current climate.
Yes. Trying to keep up without a scorecard. But I mean, when we talk about cases that come under the umbrella of ESG litigation, are the claims pled differently than traditional causes of action? In other words, as I understand it, it's not a statutory claim or even a claim that's styled as an impact and sustainability claim or an ESG claim. They're traditionally filed under more traditional common law theories, correct?
Yeah, that's absolutely right. I mean, the causes of action are still not novel. You know, you have kind of, I suppose, three plaintiffs out there, right? You've got consumers, you've got the regulators, you have investors, you know, so they all have kind of their pathways, and they haven't, you know, the causes of action haven't really changed. So if it's a consumer class action, it's pled as a traditional consumer class action, you know, under consumer protection laws that our attorneys have been successfully litigating for decades. You know, same for securities. You know, you're going to go through and make those same fundamental allegations around, you know, fraud or misleading statements, and the environmental cases are still looking at seeking relief for, you know, different nuisance or trespassers or torts. But I think what we are seeing, back to our greenwashing and even climate washing, the claims are slightly changing right now. So.
And as are how are those claims changing? What do you find?
I think, you know, when you have very limited claims around a product, say, you know, now we have those broader disclosures, and a lot of these disclosures around climate, you know, net zero, carbon neutral, they're housed in those sustainability reports. So there's more for plaintiffs to sort of target, right? So we'll see claims sounding in consumer fraud that arise from claims that a company is or will be carbon neutral, or that their products are 100% recyclable, but maybe the company is one of the biggest polluters in the world, you know, or a company is committed to reducing plastic pollution. So it's really focused on their broader statements around what they're doing at that company level, and bringing those into play into their claims, and focusing about, or really challenging, I would say, the company's impact on the environment and their goals.
Okay. And are we seeing industries that have been particularly targeted on carbon-related claims?
Definitely, definitely. We've got retail, airlines, you know, the fuel industry, tech industries are big industries that really see a lot of the share of those claims. We're seeing them being brought in the plaintiff-friendly states of California and New York, and we're seeing mixed results on their ability to survive. So like for example, in the fuel industry, most climate claims are surviving a motion to dismiss. Consumer products, we're seeing it's about half and half. And in tech, you know, one thing I think that is also very interesting is sort of seeing this movement by pro-ESG investors pushing for disclosures after they're seeing changes in practices like among partnerships. You know, maybe the company has come out to say that they are, you know, looking to do business with others who share that commitment to net zero. But now the marketplace is changing, their business strategy is changing, so maybe they're not doing that. So it opens them up for, you know, more, opens them up to attack, if you will. But I would say those are the predominant areas we're seeing in there, and some companies are even seeing both paths, you know, the consumer side and the regulatory side come up.
And I know you touched on this because I know that many of these claims have been tossed on motions to dismiss, right? So when we consider defense strategies for responding to these types of claims, can you just walk us briefly through what's working and how those strategies are evolving?
Well, I think just like the causes of actions and sort of the traditional pleadings, you know, same thing with the defense side. You know, it's sort of the tried and true defense strategies that are still being deployed and are being successful. So if we're on the consumer product side, you know, puffery, forward-looking statements, statements of optimism, those are still successful defense strategies. I think we do have a gray space though, because when you go into those climate claims around carbon neutral, net zero, we're seeing consumers sort of attach their own meaning to those terms, and where we're seeing success, you know, and in the consumer space, it's that reasonable consumer that sets the bar, and that's subjective. So we are seeing some successes, companies, and this is scary sometimes for companies, which is to sort of describe the making behind those claims, you know. But if a company can give meaning to those terms, and be upfront with those disclosures about how they can get there or what it means or what their progress is, then that's something that weighs in their favor, actually, to really, you know, say, okay, well, you know, we've told you this information is available, so it's not plausible for the consumer to be misled when we've made this information available. In the securities context, you know, the defense of aspirational statements still holds, always with a little bit of caution though, because there have been instances where it's been also actionable. So I think that's something to kind of be aware of. I would say the last thing, and these aren't, you know, they're going to be more fact specific, but they fall under the procedural side. So, you know, in this space, we don't necessarily have a true preemption, right, in the green space. There's no sort of federal law there. But depending on your industry, and we've seen this in the airline cases, where a preemption argument has been successful, sort of arguments that federal acts such as the Airline Deregulation Act in relation to greenwashing cases, those could preempt state laws. So depending on your industry and laws at issue, you know, there's a possibility to take a preemption argument. And then the last one I would say is standing. So we're seeing, you know, particularly in consumer goods, where plaintiffs, you know, aren't pleading or don't have standing because they haven't alleged an economic harm. So I think we've got that as sort of a last procedural defense strategy.
And a strong one at that, it sounds like, from cases I've read. Moving then away from the litigation context to the regulatory, what can you tell us what's happening at the federal and state levels?
Yeah, so federal is interesting. It's a little wait and see. I mean, right now, the SEC chair is going through confirmation hearings, but the SEC has been taking some steps to, I would say, do their own form of hushing around ESG, which is, you know, there were climate disclosure rules that were passed last year, promptly went into litigation. Now with the new change in administration, the new SEC has asked for all arguments to be paused at the Eighth Circuit. So we're in pause right there. We still have 2010 guidance, though, that companies will need to think about. But they're also taking efforts around the ability for companies or for shareholders to get on the ballot ESG proposals. So that sort of limits and hampers the ability of investors to kind of maybe draw to shareholders' attention what they perceive as, you know, misleading issues. And then we're also seeing some activity that's hampering investment managers from maybe engaging on these topics. So I think at the federal level, the SEC is using its power to kind of limit that ability for companies to talk and engage on climate. I think we will likely see a revocation of those disclosure rules, but what companies will need to contend with are state level disclosure rules. So there's a lot of states along California, New York, Illinois that have put forth climate disclosure rules, disclosing your GHG emissions and doing a financial risk analysis. So those are what we're seeing. So companies are still navigating a fragmented state disclosure regime.
Yeah, sort of a theme that runs throughout the discussions throughout today.
Yeah.
I know we're almost out of time. Just to wrap up, what can companies do to mitigate greenwashing claims?
Yeah, it's a tricky spot to have those disclosures out there, want to kind of roll them back, but then still be compliant. And I would say that these regulatory schemes that are out there, both international and U.S., you know, they track a framework of governance, risk management, metrics, and communication. So they give a roadmap to setting up governance over climate-related actions. And, you know, there's also, so that I think is something to look at and sort of really style disclosures and have that consistency along those frameworks. To always keep in mind that your disclosures are the endpoint. They really do need to be reflective of your business strategy and consistency, whether you think you're in advertising or you're just trying to comply with a regulation. And then I would say, lastly, give definition and boundaries to whatever terms you're putting out there around carbon neutral, net zero, these kind of climate related terms that are fodder for
For challenges. Right. Well, listen, thank you so much, Amina, for shedding light on an evolving and ever-changing area that we've got our eye on. So thanks so much.
Thank you.
I want to make sure that everybody has a chance to see and hear the CLE attendance code. The attendance verification code is SS3726. Again, SS3726, or you can scan the QR code on the screen right now. Then I think it takes you to the form relevant to filling that out for continuing legal education credit. I want to thank everybody for attending today and participating in our program. Our next Commercial Litigation Outlook webinar is scheduled for April 9th. On regulatory shifts and risks, what's ahead for false claims and whistleblower, bankruptcy, and franchise law in 2025. And thank you, everybody, for joining us.